Welcome, everyone. My name is David Carrillo. I am your host today. This is the 2021 Recall Post-Mortem. My name is David Carrillo. I'm the Executive Director of the California Constitution Center. I want to thank our sponsors, the Citron Center for Public Opinion, the Institute for Governmental Studies, and the California Constitution Center, of which I am the Executive Director. This is the second of two recall events that these three partners have presented. The first one preceded the recall and made some predictions. And now today, with the recall in the rearview mirror and the result in the bag, we're going to conduct a post-mortem and talk about what went well and what could be changed to make it go better in the future, the next time a recall happens. Our Zoom procedure today is going to be that the chat and raise hand features for the audience are disabled. Audience, we do have our welcome you to post questions in the Q&A function. Our format today is going to be, we have two elected officials, two august presidencies in the first hour. We're going to very quickly look at the Q&A after we speak with these two elected officials and pull a few audience questions out of them. I believe we have about 200 people tuning in today, so that's going to happen quite quickly. And I think we're only going to have time for just one or two questions from the audience. So if I don't get to yours, I apologize. It's just a function of volume. So two elected officials in the top part of our program. And then afterwards, we have three panelists who are all experts in their subject matter fields who will present. I will introduce them as we move to their segment at the top of the next hour. So first, here in our first segment, I want to introduce our two elected officials. California Lieutenant Governor Eleni Kounalakis is the first woman elected as the California Lieutenant Governor. She previously served as President Barack Obama's ambassador to the Republic of Hungary from 2010 to 2013. And we also have California Secretary of State, Dr. Shirley N. Weber, who is California's first Black Secretary of State and only the fifth Black person to serve as a state constitutional officer in California's 170-year history. She was previously a professor at San Diego State University for 40 years and served 4 terms in the Assembly. We are going to speak with Secretary Weber first and then Lieutenant Governor Kounalakis second. So I'm now going to switch the views so that it is side by side. The audience should be looking at just me and Secretary Weber. Secretary Weber, thank you so much for joining us. It is a privilege. I don't think you and I have ever met before, and it is really a privilege to meet you in this format discussing one of those high-profile events to happen to any Secretary of State in living memory. So welcome and thank you for being here.
Well, thank you for the invitation. I appreciate it. Looking forward to all the conversation that you folks will have as well.
I'm sure we all plan on learning a lot from this panel. So the things that you and I were going to talk about, I'm going to sort of march through the recalls evolution procedurally, and there's various things that jumped out at me that I thought were interesting to discuss as the recall proceeded in real time. One of them was the replacement candidate qualifying procedure. As in 2003, everyone had forgotten about the recall replacement candidate procedure. You know, the recall, it only happens once in a blue moon and doesn't really have a constituency. And so, you know, when it does happen, people have to sort of dust off the rule book and think, oh yeah, this is a bit of a mess. So just as in 2003, people dusted off the rule book and discovered, you know, the statutory law is actually quite unclear on how one can qualify as a replacement candidate once a recall actually does qualify. Ordinarily, there are two procedures. One is for a party primary, and the other is qualifying as an independent candidate. So in 2003, in the first gubernatorial recall, Secretary of State Shirley at the time was faced with the same mystery that you were faced with this year. Which of those two replacement candidate qualifying procedures should you impose? In 2003 and this year, both you and Secretary Shirley decided to use the party primary candidate procedure. So I wanted to give you an opportunity to walk us through your thought process. Tell us how you looked at that issue, how you thought about it, and why you decided on one procedure over the other.
Well, I think what happened was that we looked at the procedures and realized that, we didn't have first of all, we didn't have an awful lot of time to deliberate it. There hadn't been anything done since the last election to change the thinking. People had already prepared to run based on what they thought was appropriate. And so we then decided that because, and my legal counsels and others, that because of that basically was what had been agreed upon for the past time, that we would use that again, rather than trying to change and alter everything and send everybody even in more to the courts than they were already going to run to the courts to deal with this process. That was number one. we tried to use those things that were familiar to people who would run for office. And we also then added the piece about the basically letting people know what your finances are, and simply because that had also been an issue before. And while the law had been passed and the courts had kind of struck down the part concerning the presidential piece because of the fact that this is a statewide group and we're trying to impose some kind of standards on the federal government, we knew that the other piece was still there, that the piece that dealt with the running for governor. And since there's so little that we have to be able to give folks, we don't have a long time frame, we don't have a primary and a general election, we don't have all those things because of the quick time frame of 60 to 80 days. We thought that at least we could try to do is give people as much information as they could get concerning the candidates. And that we knew if you're going to run for governor in California, you ought to be able to provide this information. That's what the legislature had said. So we decided to use that in addition to the things that have been done in the past.
That's interesting. So it sounds like the conclusion was more to, the determining factor was more to do what tradition had already established rather than sort of to make a call on one of them being more appropriate than the other. Is that fair to say?
It's fair to say that we tried to do what people were familiar with, knowing that we didn't have a lot of time to change a lot of things. We knew that there would always be someone hollering foul no matter what we did, and they didn't necessarily holler about that one. But I recognize the fact that there had not been much conversation at all concerning recalls. And we had a lot of folks giving us an awful lot of suggestions for change immediately. And given the political climate that we were in, we realized that, that maybe it was not the time to do that, but to do it when we finish this election. Yeah.
That makes a lot of sense. And I do have to include myself in the group of people who weighed in with opinions on what the Secretary of State should or should not do in that circumstance. So I apologize for being part of the barrage of opinions.
That's okay.
You were busy enough without having to.
Busy enough, yeah.
Yeah. So, on the outside, one of the things that that occurred to me was it looked like a fair reading of the statutory scheme allowed the Secretary of State discretion. And the California Supreme Court, in the context of the 2003 recall, largely viewed it the same way, and essentially said it's a judgment call. The statute is vague. It's up to the Secretary of State. Secretary Shirley went with the party primary candidate procedure. That's fine. So I think, I think number one, you're right. You would have been sued regardless which direction you went. But I think the way the legal landscape looked, you would have been on firm ground either way, because the courts have pretty clearly said it's a discretionary call for the Secretary of State.
Well, they really didn't, to the extent that they struck down our desire to basically have everybody basically put in their taxes. So they didn't say
on that point, yes,
you got discretion to do what you think is right based on who's qualified to be governor and what we expect our governors to submit. So that was one of the tests that didn't. So we weren't necessarily sure that this was the same kind of, and that's one of the challenges when you take something to court, depending on the judge and the perspective and the times and those kinds of things, that makes it difficult. So not wanting to get too entangled with too many issues that we were, that might have said, well, this is what you did last time. We want to stay with precedent because you don't have any legislation that changes it, blah, 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 with the first question. So that's why we realize that unless there is some real discussion about it and some change, we would probably be challenged because of what happened in the prior discussion with regards to the judiciary. Yeah.
Well, let's move on to the certification process. Many people who were looking at the recall from the outside were making predictions about when the signature certification process might end, and then you project that forward, and that allows you to guess when the recall date might happen. A lot of those projections turned out to be wrong because the signature certification process happened so much more quickly than most people assumed that it would. There were a few people that said, yeah, this could happen a lot faster, and you'll be surprised with an earlier election date. But I was wondering if you could tell us, how did that happen so quickly? It's rare for government to move that fast.
Well, really, if you look at the time frame that was there, it really, we pretty much kept it to what was going on, and the fact that many of the signatures had already been certified because the process was so long. It was not like it was the typical process, and all of a sudden you've got a barrage of this. This thing had been going on for over a year in terms of the recall, and so as a result, a lot of the signatures that had come in had already been there, and so we took as much time as our county folks gave us in terms of what they had certified and what they had available to them. We took the full 30 days to basically allow people to take their names off, because we wanted people to have that, so if the process is going to move, we can slow it down a little bit and not as fast. The legislature then decided it wouldn't take its 30 days. And that's what kind of, I guess
that had a big effect.
A big effect, much more than people certifying the signatures, because there were only a few days that we took off of that. But the fact that the legislature had made a decision of what it was going to cost and what have you, and then decided they would forego the 30 days that they had, put us all in a much faster pace than what we thought would be. And that had more of an impact than anything else. And we were not a part of that. We just discovered that it took place and that it happened, and that was a decision that was made,
Right.
So, yeah.
Yeah. It's so that necessarily impacted the other big part of the Secretary of State's office's responsibilities with regard to setting a recall election, which is choosing the date. In that instance, your office has to coordinate with the Lieutenant Governor's office, because the Lieutenant Governor is the one who actually declares the date. But what's not written in the law is a very important predicate to the Lieutenant Governor choosing the date, which is your office determining what dates are possible or feasible from, just from a mechanical election standpoint. Because, other than choosing the date, the Lieutenant Governor's office doesn't actually run the election. It's run by the county election officials who are, coordinate with you. So the choosing of the date actually involves your office, quite substantially. So I was wondering if you could tell us, how you thought through what the options were for setting the date.
Well, we knew that we had a certain time frame in which we needed to get the information to the lieutenant governor, and she would have she had a time frame of 60 to 80 days in which to do that. And as a result, we knew there were certain things that had to happen, and not that I knew, but those who work the elections all the time, who were telling us that I need so much time to order paper, this. And so within that, we knew there had to be a time frame in which all that stuff could be done. And so when we gave it to her and we said, these are the dates that fall into, once we give this to you on September, I know it was, July 1, these are the dates that kind of fall into that. And then she was the one who basically could say, okay, I don't want to do it on Labor Day weekend because that becomes too difficult, and this and that and so forth and so on. So she tried to make it as far out as we could within law, within legal limits, because we knew people needed an opportunity to get their papers in. We knew they needed an opportunity we need to print all this stuff. We had to print envelopes. Even the issue of just ordering paper, making sure we had a vendor to order paper, that was extremely important. And had it not been for the counties who had been anticipating a recall and start talking to our vendors early, we would have difficulty getting paper because of the type of paper that's there. It's very unique and so forth and so on, and making sure we had adequate vendors to print the things. And so there was a lot of things that normally they have a very long time to do. We had a very short window of opportunity. We had very few vendors. I think we had 2 who could actually supply us with the paper that we needed. And the printers and those kinds of things. We did most of the printing, but some of the other things that had to happen with regards to just making sure that the election comes off. Plus, we were working with that. I forgot how many days, 40 some odd days, that we had to have ballots in the hand of those overseas. That 40 some days before the election. So there were so many restrictions that we had. It's almost like, trying to do a chart of what has to happen when and where and how many days you have for this versus that. It was very complicated. So in the end, as we looked at what was coming to us and the fact that the legislature had given us their stuff early, and we had a turnaround time to get that out to the lieutenant governor. And once that happened, then we had to make sure that there was opportunity to get the election done. And I think she probably pushed it as far as she could to make sure that it would happen, but we had to do it within the 80 days. And I think it was, I don't know, whether 70 some days or whatever it was from the moment that she said we're having a recall to the time that the recall took place. So there's a lot of things that have to happen, and you have to give people an opportunity to do certain things. And we were basically a chart that really drove it. People talk about politics. It was not politics, it was a chart. It was the deadlines, the dates, the filing, the printing, the this, the that, the stuff that had to get overseas, the ballots that need to come in, how much time you have for this, that, and the other. And, and it all came together. It was quite remarkable that the staff knew more about this E45, which is in so many days to the election, than I did. But we knew that we had to meet all those things. And we had several different charts that said, if you do this today, then this is when it happens. But if they take 20 days to read this versus that, if they take so many days for this, and so forth and so on, we kind of knew all the different dates. And somehow it came out to be about 2 or 3 dates that the lieutenant governor had to choose from.
Right. Yeah, it's a little amazing that all of it happens so quickly. And congratulations to those folks who decided to order the paper early, because that would have been very embarrassing if we had to have an election and not on paper. Yeah, we didn't have the paper to do it on. You mentioned politics, and again, from the outside, I think that there was some commentary, and it kind of stands to reason. It's sort of common sense for folks to have a little bit of a suspicion that behind the scenes, there's at least the possibility that politics could enter into it. Somebody could make a phone call and say, hey, if you do this thing more quickly, or you set this date a little earlier or a little later, that could be helpful to one person or another. That's the perception from the outside, but along with that also is it seemed from the evidence available to those of us on the outside that didn't happen. And I wanted to give you a chance to weigh in on that. Was there any political maneuvering in the background?
There really wasn't. We were more concerned about the laws and the rules and regulations and how much time you have to do this versus that, whether or not we have all these things in place and seeing the stuff printed, blah, blah, blah. We were more into that. The reality is someone said, well, we think you picked September because it's a better date. Some guy told me that recently. And I said, you know what? I always used to tell my students, if you're going to be a cheater, be a good one. Don't be a dumb one. Don't leave your cheat sheet in your seat, as one of my students did after he finished cheating on the test, lifting his leg at every question, and then gets up, turns his paper in, and leaves the cheat sheet in his seat. That's amazing. Be a professional cheater if you're going to be one. September is not a good time for an election, period. Right. It is just not a good time. You got kids going back to school. You got people ending vacations. You got everything on people's minds other than an election. So when you think about it, I said, if there were my preference in terms of me thinking when's a good time, when are people more focused on it, it would have been, I don't know when, maybe October, November, whenever, but it would surely not have been September, just as young people are beginning to go back to school, universities are beginning to go back, students are moving in the dorm. You just got a lot of motion going on, and all of a sudden somebody tells you, oh, we have a recall, okay? Or even the campaign in July and August. And so it's hard to get interest in an election when you've got that. And most folks believe, whether it's true or not, as a Democrat, that it is harder to get Democrats to get fired up over recalls as it is others who put the recall together. So That was always a concern. So you're going to figure out when is a good time to get people fired up. September 14th is not a good time. I mean, it just isn't. So if we're going to pick a date, I'd pick something, I don't know when, but it would surely be better than that. That was not a part of our discussion. Our discussion was, we have a certain amount of time to get this thing done. We want to make sure that we can do it, that we can actually be fair and honest to everybody that's in it, that we can put this stuff together. We can get these things printed. We had ballots to interpret and reinterpret in terms of languages. We had new languages added. I forgot whether it was a Russian ballot or whichever one had to be done several times, because who did our interpretation didn't do it in the way that it should have been done, and it wasn't clear. And so we had to redo that. I'm standing in the printer's office as the people in another room, basically interpreting the Russian ballot, I think it was. So, so there was a lot going on. And the last thing in my mind is this a good time for a Democrat to have an election? Come on, we've got things to do, and we had parameters, real parameters, about 60 to 80 days. And that becomes the limitation. People say, why couldn't you guys go in November? Well, we couldn't. Why can't you go in next June? Well, the law doesn't allow you to do that. The stuff that comes in a certain way at a certain time has some limitations, and we had to live by those limitations.
Yeah, if anything, the strongest case I thought for likely political maneuvering was if everyone had taken the full amount of time that they were permitted, And that probably would have set the likely election window sometime in the holidays. Like December
Yeah.
was actually a real possibility. And if that had happened, then it would have been a reasonable argument to say, well, the Democrats put it in December because they're basically burying it during the holiday season. Nobody's going to be paying any attention to this kind of thing. But that's not what happened.
No, it's not. And most people believe that when there's a low voter turnout, it's because the Democrats don't show up. So, so I don't know. There's always a reason for something that doesn't seem to have as many negatives as it has positives in terms of the reasoning itself.
Right.
So I've kind of made sure that whatever we do is right. And even if it's, folks will say, well, you could have done it differently, but as long as I know that what we were doing was the best we could do, I mean, that's about as much as you can expect.
Well, I appreciate your commitment to integrity. Let's move forward for a few minutes from what happened to change that could be considered for future recall campaigns. Not that I'm hoping that we see another one anytime soon, but it's going to happen at some point, whether it's in the near future or farther in the future. So what are the lessons or takeaways for you as far as changes that could be made to the recall procedure to improve it? There are a number of proposals floating around. Are there any that you particularly favor or disfavor?
Well, I've been on calls with a number of persons who have various proposals, as well as how we should address the issue of recalls and whether or not we should continue with recalls or whether we should be looking at constitutional change in terms of California's recall election. Mm-hmm. It clearly is a flawed election. I mean, flawed process that people recognize. And so there are a number of things that people have talked about. I'm hoping that it won't be a Shirley Weber show, that it will be a discussion across California. That's my goal, because it's, because what I saw was the administration of it and how difficult it was to do it in such a short time frame, that was there. That was one piece. People saw it in terms of, is this really the will of the people? And some believe that because of what they saw as the outcome, that the recall can be such a personal thing, that it's not necessarily a policy issue. It's not something that people have violated the law, that is strictly somebody who wants to, get rid of the governor. And so as a result, everybody has to pay for that. Over $300 million probably has to pay for a small group of people who decided they want a recall. So there is concern about the number of people who can actually get a recall, that maybe there needs to be a higher number than the 12.5%.
I mean, the signature requirement to qualify.
The signature requirements to qualify to get on the ballot, because once it qualifies, we got to roll with it. We got to get it done.
Right.
And so there's a concern about that maybe there needs to be a cause or reason for the recall to exist, rather than just you can get that many signatures, because we're seeing recalls now up and down the state where people have been in office since last November, December, and they're already people trying to recall them immediately when the time frame comes that they can do it. Why? Because these are the same folks who voted against them in the first place. So, so we need to look very carefully at the rationale for doing recall, whether the number of signatures, whether there needs to be some discussion, as we've seen some folks say it should be because they committed a crime, they've done their election of duty, whatever. There needs to be some rationale for it. Should it be as close as it was to a primary election? You spend this money and now you're getting ready for a primary on the same people, so what are the parameters? Should it be so close? Should we have it so close to the beginning and so close to the end of a term when you could just simply vote to put somebody else into office? So those are the kinds of things that people are looking at that I think are reasonable to talk about. There's also questions of whether or not we should do recall at all. Some states don't do it, whether we should basically have a different kind of system, kind of like an impeachment system, that that you have to have cause and reasons for people actually being removed from office, because the election supposedly does that. If people are paying attention, that's your opportunity every 4 years to get rid of people who you don't think are functioning in your best interest. So those I think those are conversations that need to be discussed. Should California continue with the recall period? Most states don't. If it is, what should it look like? Should there be some reasons for it, some rationale for it? If there is a recall, do we need a replacement as candidates that are there? Because that frustrates people more than anything, because now you're trying to figure out, if I don't like this guy and I don't like the 46 people that are on the list, what am I supposed to do? And so that becomes an issue, as if you're buying into something that you don't know what you're buying into, because you don't have a second election. You don't have anything of that nature to come back to. So that people had more frustration, I think, with that than anything else. Some said, what is a lieutenant governor for? if we remove the governor, is that not what the lieutenant governor for is, to step into the place of
we're about to talk to her, so we'll find out.
I mean, and I think, at least you know what you're asking for. At least you know what you're going to get if you recall the governor. Right. Where with the 46 or last time 135, who would win in the end. So those are the kinds of things I think that have to be addressed. That is this really a process that's fair, that is just, that allows people to know what they're getting. Some folks said, I felt like I was buying something in a bag and I didn't know what I was going to get because there was so many people. I didn't know who was ahead, who was behind. I didn't know what they represented, and it's 46 of them. So you end up with one that, and it was clear, as most folks said, no matter what happened, it was fairly clear that if we had recalled the governor, that whoever became governor would not have the majority of the folks in California supporting him.
That's a risk.
That would have been true. That would have been true. So it has a lot of limitations as a process. I'm hoping that I've been talking to folks who've been calling me. We were talking, hopefully, to figure out whether we're going to try to do it as a quick commission or a study group or something. But I think it has to be addressed, and it needs to be addressed in a bipartisan way in which we look at it as to what's the best interest of California. I'm hoping to get the kind of input that I need as Secretary of State to work with our two election committee chairs in the Assembly and the Senate, and then hopefully to have something ready by the first of the year for the legislature to begin to look at and the public to look at, to see if whether or not we're going to be able to do something in terms of changing our recall structure and the laws, and obviously get it through both houses and then try to put it on the 2022 ballot. That would be ideal, but I know process and legislature doesn't always work with ideals, so we'll do the best we can.
Well, you mentioned a number of the sort of top shelf ideas for or variations that exist in the recall. There's about 18 or 19 states, depending on how you count it, who do recalls, and there's significant variation among them as to what procedures they use. So some of these ideas that you've mentioned and that are being kicked around in California, they're things that exist in the recall procedures of other states.
Right.
So to some extent, we'd be borrowing from them. We can learn from their experience about what works well and what doesn't. I also should mention here that I can volunteer, certainly myself, and I'm sure the other panelists, Josh, Thad, and Jessica, we all have some thoughts and some expertise on the recall process in general, and we're all intensely interested in the reform proposal. So if you and your friends in the legislature would accept some academic support and commentary, I'm sure all of us would be happy to jump in and get involved in that.
Well, I'm sure we will. I'm sure we will. We'll be looking at a variety of, and there's been a number of recommendations as to how we do it, but we would value, I think, the input of those that are there that are willing to participate in the process. My hope is that, as I told someone from the beginning, this is, I'm not going to sit in a room and write the thing myself. I think that is very, I would love to think I was that brilliant, but God knows I know myself when I go to sleep at night that I'm not. And so, I would love to have, I think, this kind of academic as well as public discussion of what we see, what we want, and then to begin to work on it. I've already asked my staff to begin to compile, and they have since the recall began, as we began to grapple with all these problems, to basically start a file for me of all the, and some of your articles are in it, some of you folks' articles are in it, but various articles, discussions, what's happening across the nation, what other states are doing, how they operate, those kinds of things. So I've already got a file of that stuff that they began to collect from me.
That's amazing. So usually when the government says they have a file on you, that's not a good thing, but here I'm quite proud.
This is a good thing. Well, you keep in mind, I come out of the academic world.
I know,
so
right?
I value information, whether you can use it or not, I value it. I want to know what people think. And so we've got a file of this material that we're using that we will hopefully be able to share with those on a commission or a quick group. We don't want a huge group because we don't want to take forever to have this conversation. Right. But I think many of you have done enough work, and some others have worked in communities enough. And those who work with elections, even our election officials, know the challenge of administering such a quick election. And the uncertainty about what you're doing and what it's going to turn out to be and those kinds of things. And people in the state were very frustrated with the last election and not having enough information, not having enough time, and not believing that it was necessary. And then when they saw the results, they really were angry about the money that we spent on an election. But as I pointed out to them, this is a law. We couldn't change it. I couldn't say, well, doesn't seem to have a lot make any sense to me, so we're not going to do it. We didn't have that option. We didn't have that choice. We had to implement a recall because the signatures were in and they had qualified, and so we had to do the best we could to make it as fair and within the law as we possibly could.
Secretary Weber, I'm very pleased that we've had this conversation. And as I said, your colleagues in academia are at the ready to assist you. You also mentioned the Shirley Weber show. I would watch that show. I think that would be pretty interesting.
Well, it would be fun, no question. Yes.
You and I are out of time, and I'm going to thank you and switch to the Lieutenant Governor. It's really been a terrific conversation. I'm very glad we got a chance to talk through some of these things. And I think you did the Lord's work in making this thing happen under pressure and under the gun, with everybody looking at you and people like me complaining about it on the outside. So, God bless you for your public service and your dedication to integrity. From me, I really appreciate it. And you've been terrific today. So thank you.
Thank you. Look forward to working with you some more on it. Take care.
I hope so too. Thank you, ma'am. And now I will return to California's Lieutenant Governor, who I'm going to make side by side. Madam Lieutenant Governor, you look fantastic. It's such an opportunity to see you. I'm so excited.
Well, can I just say, I can still see Shirley Weber. Dr. Weber, you really just did such an extraordinary job. And as David was saying, just a pillar of integrity through this process. So it's an honor to be here and to follow Dr. Weber. And if there is a Shirley Weber show, please sign me up too.
I would absolutely subscribe to that. Madam Lieutenant Governor, thank you so much for joining us. It is a pleasure to have you. We have a few things to talk about here. So let us dive right in. The date. First of all, tell us about the Lieutenant Governor's role, the constitutional role that office has in setting the date. Secretary Weber just walked us through a little bit of the interaction that the two of you had, and it sounded like from her perspective that given the speed of the recall's qualification and the realities of the calendar and such critical but mundane matters as ordering paper, of all things, a number of factors combined to limit the universe of options that she was able to present to you to say, these are your choices. How did that process go from your perspective?
That's right. Well, David, it was a very interesting thing to go through and to be part of. But there's always this kind of dual reality. And one is the reality of the statute associated with recall elections and how very, very specific they are in many ways. And then the politics and the perception and the media. And so for my part, very early on, we had experts advising us on what the statutory responsibilities of the Lieutenant Governor were. And then there was the media saying the Lieutenant Governor will set the date, as if I'm setting the date out of thin air. Right. And so part of what I think was really successful in terms of orchestrating this according to statute is that Dr. Weber's office and my office, and we had staff level conversations, a few conversations between the two of us. It was all technical. What do we need to do to ensure that we are living up to our responsibilities as constitutional officers responsible for conducting this this process? Of course, she conducts the elections, but then again, I have this role. And it really was by the book. And the other thing I think that was a good thing is that on the perception side, it's always very tempting when you're in a political office to people around you are saying, oh, grab the spotlight. But there was nothing good about my office or the secretaries or anyone confusing our role for what it was, which was a purely technical role in making sure that once the recall qualified, that we did what was necessary in order to make sure that we proceeded in a way that was consistent with the law.
So what was your thought process? As I understand, the Secretary Weber's office came to you and essentially gave you three options. That they had boiled it down, and there were, I think there were, am I wrong? Was it two or was it three?
So it actually, so we didn't wait around until that happened.
Really?
We were following every part of the statutory process, so that we ourselves had an independent understanding of what those dates were likely to be. And so at a certain point, it was sort of the last lever when we knew when the certification would take place. And I would say that was probably by the beginning, at the end of May, by the beginning of June, we had a pretty good sense. And then when the process played itself out, at that point, there were 2 dates. But we actually did this, we had this very complicated spreadsheet of all the various triggers, and depending on the date that those things took place would determine what our choices were. But yes, by the end of it, there were 3 dates within that window of 60 to 90 days. And one of them was disqualified because it was the Tuesday after a holiday.
Labor Day, right?
Then, yeah, so then there were just 2 dates left.
Okay. So yeah, I mean, you mentioned the opportunity.
And by the way, I chose the one that was right in the middle, between the day after Labor Day, which was disqualified, and the later date. I picked the one that was right in the middle.
It's very Solomonic. You mentioned the incentive or the opportunity to grab the spotlight in this process. Secretary Weber mentioned it as well. And one of the reasons that incentive exists, aside from the function that you both served here, is the underlying California constitutional design feature that both of you are independently elected constitutional officers. I mean, I realize that Secretary Weber was appointed to her position, but her office is independent from the governor's office, and so is yours. So there's that reality of the political incentive, and then there's also the reality of the fact that you don't hold the office that you do by anyone's grace; it's by the will of the voters. So if anything, it's sort of the perfect opportunity for a couple of state officials to strike out on their own and advance their own interests. Secretary Weber's perception, as she explained it to us, was very ministerial and very mechanical. No, this is the job, and these are the dates, and this is what I have to do, and that's what I have to do, and that's what I did. Do you view it the same way?
Yes, exactly the same way. And certainly she had various steps and determinations to make, more than I did. But I was very, very impressed with the approach that she took. And again, the culture of my office is very similar. In our democracy, the responsibility, the oath we take is the oath of office to the state constitution, the Constitution of the United States. And it's our duty to follow those. But it's also, on the perception side, so necessary in the current environment where there's so much distrust of government to really do our part to try to build faith and trust that government officials are doing their duty per their oath of office.
It's interesting. Will Rogers once famously said, I'm not a member of any organized political party. I'm a Democrat. And one line of commentary over the summer was speculation that there would be the kind of disunity that we saw in 2003 with the lieutenant governor at the time, Cruz Bustamante, putting himself on the ballot as a replacement candidate. That kind of disunity was not seen, in fact, quite the opposite here. So I think that speaks to the yes, there are certain incentives to go in a direction, but there are other more powerful incentives to go in the direction that you and Secretary Weber actually did, which ultimately leads you and the Secretary in the direction of that kind of unity. So, one question that can get raised on the outside is that one thing that influences that all hands on deck and everybody stay on message dynamic is politics. That that there was a for lack of a better word, a conspiracy or coordination with the governor's office to do what's best for the governor's interests. It sounds, from Secretary Weber's perspective, it sounds like she had no part of that, and no secret phone calls were made. What was your experience?
So again, I think there are two hats, and in her case, she had more steps all along. She is the Secretary of State. They're responsible for the election, so she had to stay out of the politics of it as well, even though, as you noted, she is in her position because Governor Newsom appointed her to it. And frankly, I will say, I think she did an extraordinary job in doing that and projecting to people that as the Secretary of State, whose job it is to oversee this election from beginning to end, she is not going to wade into the question of should the governor be recalled. Now, in my case, there was more latitude. I'm the lieutenant governor. I'm not the Secretary of State. I had this narrow job. I kept it very technical, and I did what was appropriate and necessary, and we were very, very careful. But I also am the lieutenant governor of the United States, and there is much more of a political role that the lieutenant governor plays in recall elections, because so far in California's history, only 2 recall elections have ever qualified for the ballot, only 2, including this one. And in the last one, the lieutenant governor put his name on the ballot as an alternative.
I noticed that you did not.
That's right. So let's carve out that I will absolutely stand by my firm commitment and my duties under the Constitution to pick that date through the window that was given to me. And I think that is beyond a doubt that we did that in a transparent way that honored the duty of the responsibility of the office in that very narrow way in the recall election. But there's also the fact that from the very first days, people were calling me and texting me, including Cruz Bustamante, saying, do you want to talk about your options? And some people even saying, you need to put your name on the ballot. Even Democrats who were very angry particularly about the French Laundry thing, which just blew up in a way that, in my view, at a certain point defied logic, is very, very emotional at a time when people are very, hurt and struggling through COVID. So I understand that part of it. But when I put that hat on, that was a very different experience. And it was political. My engagement in that realm was political because I came out very early. I said I was strongly against the recalling of Governor Gavin Newsom, that I would not, if it qualified, this was even before it qualified, if it qualified, I would not put my name on the ballot. And I thought it would be shameful for any Democrat to put their name on the ballot.
What was your thought process for removing yourself from that conversation? And how did you respond to what it sounds like was a fair amount of political pressure to not do that, to put yourself on the ballot?
Well, I wouldn't say it was political pressure. It was more political temptation. and I did not take the bait. And for a couple of reasons. Most notably, I lived through the Gray Davis Cruz Bustamante recall. I was working in business in Sacramento. I was close to the governor. I knew him. My family knew him. I was close to Cruz Bustamante. He came over to my house for dinner once, just kind of on a whim. Family dinner night at my house with Cruz. Very nice man. But when all of that went down, and at that point, remember, it was historic. It was the first recall that had qualified. And what happened was, because there had never been people going down this path before, and because recalls are so confusing, should the governor be recalled? If so, who do you want? And the governor's name's not going to be on that. And this idea that the recall, the governor could be recalled having 49.99% of voters saying, no, don't recall the governor, we want him. And maybe 30% of the voters say, we want this right-wing Republican. Not in Arnold Schwarzenegger's case, I don't think anyone would call him right-wing, but certainly in this case. So the territory was not uncharted. We had been through this before. And so I knew from my own experience that it was too confusing to say no on the recall, yes on this alternative. And so I got out there very quickly and I went on national TV and I said, I'm not putting my name on the ballot and it would be shameful for any Democrat to do it. Now, the reason, the ultimate reason was because I believe in good governance. I believe in our democratic system. And I do not believe that any shortcomings of the Governor Newsom, rose to the level, essentially, of impeachment, of being recalled. I just didn't.
That's the standard you used.
That was my standard. We elect governors every 4 years. We need to let them do their job. He was elected by double digits, something like 26%. He beat John Cox. And now John Cox is going around with a bear saying, thinking in his mind, I lose to him 2.5 years ago in a regular gubernatorial election, but because this recall, we can hack the recall process.
It's a free reshot.
That's how I saw it, David.
Okay. Let's switch gears to talking about lessons learned from the experience that we just went through. Obviously there are takeaways. There are things that went well. The mechanical process of actually putting the recall election together happened at lightning speed. It was frankly amazing. I was very impressed with Secretary Weber's description of that. So good for us. It went off on time and relatively well. But I think now people are focused on what didn't go well in that process and what lessons we can draw for moving forward and how we can conduct recalls and direct democracy in general in the future. So what in your mind, what are the takeaways here? What are the lessons learned from this process?
Well, again, I'll just underscore it's only the second time that one is qualified, and that's interesting. It's also evidently only the fourth time that a recall of a governor is qualified anywhere in the United States.
Yeah, that's one of the interesting things about studying the recall in general. And if you stick around, you'll hear about this more from my colleague Joshua Spivak. But one of the counterpoints to the argument that the recall is overpowered in California is the empirical reality that they are frequently attempted, but they rarely qualify, and they almost never succeed. So I think that's a pretty strong counter argument. Like, yeah, you can tilt at this windmill all you want, but it's going to be a fluke if you succeed.
I think that's right. And I think that was the lesson learned about our particular system during the Davis administration, and why, again, it was so clear to me that it needed to be framed as the governor versus the recall. But anyway, so lessons learned and going forward. So again, LA Times has editorialized, others have said, 2 questions. Keep the first question, should the governor be recalled? Drop the second question of who should replace. And if the governor is recalled, the lieutenant governor should step in. So
how do you feel about that? You are the lieutenant governor. How do you feel about that?
I do have feelings. And
yeah, you're involved.
You asked me, but very few people actually, that's my opinion.
How does that make you feel?
I'm a little surprised they don't ask me before they get out there. So I actually don't think that is a good way to reform the process if it is reformed.
Interesting.
Because for a variety of reasons. And you and others are, I'm sure, going to be involved in the process of breaking down, what would be a constitutional amendment for how to reform it in a way that would work better. But on this one piece of the question of doing away with the second question, only keeping the first and having then the lieutenant governor step in, I actually don't like that idea.
That's another interesting instance of you sort of straining against or acting contrary to what would seem to be your own political interest. Why is that?
Well, I actually think that, well, I suppose it depends on how one sees their political interest. I believe, and I am new to elected office. This is my first one, surprisingly. But I am very proud to be California's lieutenant governor, and I hope that I'll be reelected and I will be able to serve as California's lieutenant governor for 8 years. Maybe another time we can talk about this role more fully, but I have found that it is an extraordinary platform to be able to work on important policy issues for the state, most notably public higher education. I sit on the CSU and the UC boards and worked with the governor and the legislature to also serve on the board of the Board of Governors of the California Community College system. So I really like my job. I really like my work. But I also have the opportunity to do things in concert with the governor. Now, it isn't part of my statutory duties, and sometimes you will have a lieutenant governor who is not going to be able to collaborate with the governor. But at a minimum, you shouldn't have a system that incentivizes the lieutenant governor to want to see the governor fail. So again, in my case, he appointed me to his task force for recovery after COVID. The governor appointed me to his Council of Economic Advisors. I'm not an economist, but I have my MBA from Berkeley. And those are very confidential conversations that I'm included in as a result of being on that commission or committee or council. I also serve by executive order as his representative for international affairs and trade. Today, I had the honor of welcoming a delegation, high-level delegation from Ukraine. And I am there meeting with him, helping because he does not have time with everything else he's doing to meet foreign dignitaries. I'm a former US ambassador. He and I have agreed that this is something that we could collaborate on and do together for the benefit of our state. If the governor thought that over the last 2 years, if a recall attempt qualified, why would he want me to be on the inside of any of his advisors or with the people who advise him or on the inside of his thinking before he decides on which policies to move forward with? Why would he trust me? Even though we're of the same party, even though in this case we know each other, if it were in the back of his mind that I am incentivized by his failure, even in the, like, okay, so certainly you have a situation, I might be of a different party and there might not be this opportunity, or maybe there are personality conflicts. But in that spectrum of wanting the governor and the lieutenant governor to at least, have the best possible relationship, whatever that relationship is. In the case like mine, where it's very good and collaborative, again, I still hold firm that I don't work for him, but I can work with him where our values, our interests, and our priorities align.
It sounds like it's a matter of, as you said, how you define that political interest. And your view, it sounds like, is that your political interest actually lies with the governor, that your fortunes are tied together.
My political interest is in not wasting 8 years of my life in this job. It's being able to do something. And whether or not you're a person like me who, again, happens to know the governor. I've supported him for 18 years since he ran for mayor of San Francisco. It is an unusual circumstance that we have this kind of relationship. But even if it were a relationship that wasn't super collaborative, right? When the governor leaves the state, the lieutenant governor takes over. If the governor is incapacitated, the lieutenant governor takes over. You just don't want the lieutenant governor any more incentivized than she or he already is by the circumstance of being that vice governor. To think that there's an opportunity to elevate if something goes wrong for the governor, because at the end of the day, we should all want our political officials to succeed when they are working for the interest of the people.
I think that one other factor that folks who are in favor of this idea don't consider is the very real risk that you might not have unified party control, which would only exacerbate the risks that you're pointing out. And that could go either way. It's a Republican governor and a Democratic lieutenant governor, or the other way around. Just the mere fact of having somebody from not your party being second in command and ready to step into your shoes if you should shuffle off or get recalled. It's the alligator in the bathtub. It's not something that one could ignore.
Exactly. It's already the case if, God forbid, something happened to the governor, right? But there's no that is the worst case scenario that an act of God would create a circumstance where the lieutenant governor would be elevated. But in this case, it's a political process that would elevate the lieutenant governor. I don't think you want that.
So what kind of reforms are you thinking are worth looking at? There's a number of proposals floating around, or are there any that you think are particularly meritorious and worth discussing?
So again, nobody's asked my opinion.
I'm asking. I'm asking you right now. We have 5 minutes left. I want to know.
And I have been working to try to sort through some of the things that I think would be better. But there's no question that if my voice is to be heard on this issue at all, it would be on what we just discussed. But beyond that, Gray Davis, again, is an old friend of mine. He was a lieutenant governor before a governor. We've been talking about some ideas we might have. I think really what's critically important in all this is that this other kind of problem with the ballot is what I outlined a few moments ago, which is that the possibility that more people vote to keep the governor in office than vote for the person who would, if the governor were recalled, replace him or her.
It's the plurality replacement rule.
That's a problem. That feels wrong. That feels undemocratic. And so that needs to be fixed. And I think that, and I don't know if Dr. Weber weighed in on this, I certainly hope she does, but how to fix it, again, without necessarily having a very, very expensive and drawn out process in between elections that we already have in California frequently enough.
Madam Lieutenant Governor, we are out of time for this segment. Unless you have one final closing thought, I can give you one more minute, but I feel like we've covered all the things we meant to talk about.
David, I just want to thank you for your commitment to our beautiful state, and to everyone who's participating, for caring about good governance and caring about the tedious work sometimes of reforming institutions when necessary. When I was U.S. ambassador in Hungary, we would counsel, and some of you might know some of the things that have happened in Hungary over the last 8 years, 10 years. But democracy is always a work in progress. And the people who are out there doing the painstaking nitty gritty work of governmental reform, I think really need to be hailed and thanked, because you may not have, a couple million Twitter followers because you're, taking a sledgehammer to things, but rather trying to figure out how to fix the system through reforms rather than necessarily take a sledgehammer to the system as a whole. So I see it and appreciate it.
Well, Madam Lieutenant Governor, those are wise and kind words, and they are much appreciated. And don't think I didn't notice that you have California's poppies as your color scheme today. That's well done.
I had the Ukrainians here, so I was representing today.
Well done for representing our state. Thank you, Madam Lieutenant Governor. I appreciate it. It was wonderful talking to you. We are now going to take a 5-minute break before we switch to the second portion of our program here today. So I'm going to briefly turn off my video and everyone please take a 5-minute break. We will resume at 5:05. All right, everyone, welcome back. This is the second half of our program today, and we're switching formats. You'll hear a lot less from me. I'm going to briefly introduce our 3 panelist speakers today, and then I'm going to turn it over to them. I might have some follow-up questions. I'm still going to be monitoring the Q&A feature. There's only been a few things that have come in, which we unfortunately didn't have time to get to, but you're still welcome, folks in the audience, to put in any questions you want in the Q&A, and I will be watching that to pose them to this panelists as time permits. So let me now introduce our 3 panelists. First, my friend and colleague, Josh Spivak. He's a senior fellow at the Hugh Carey Institute for Government Reform at Wagner College and a public relations executive. He's an expert on recall elections and has been for the last 20 years. He writes the Recall Elections blog, and he recently co-authored an article in a Harvard policy journal with me. So welcome, Josh. He's going to be our first speaker. After Josh is going to be Fad Kousser, who is a department chair and professor of political science at UC San Diego. He held the Flinders Fulbright Distinguished Chair at Flinders University in Australia. I can't believe I didn't mess that up. And has worked as a staff assistant in the California, New Mexico, and U.S. Senates. Professor Kousser is also a go-to expert for many national publications. Our closer today is going to be Jessica A. Levinson, who is a clinical professor of law and director of Public Service Institute at Loyola Law School. She is a frequent news commentator as an expert on legal issues. I frequently look for her in articles to find out what's going on. She was the president of the Los Angeles Ethics Commission and is the founding director of Loyola Law School's Public Service Institute. Welcome, everyone. Thank you for participating. Josh, I'm going to pin you, and then in a second, I'm going to remove myself. Whoa, what happened? There's Josh. Thad and Jessica, go ahead and turn your video off. Thank you very much. Josh, I know you have some prepared comments, but somewhere in there, I hope you'll have time to cover briefly something that Secretary Weber mentioned in her remarks. She was talking about instituting a change in California's recall procedure to require a substantive reason for the recall. I know that that is the states that do that are called malfeasance states in the recall study jargon. So somewhere in your remarks, I hope you'll talk about that a little bit and discuss the pros and cons of including sort of a substantive requirement for malfeasance for recalling an official. I'm going to unpin myself. Take it away, Josh.
Okay, I guess I should share the screen. Thanks for having me on, and thanks everyone for being here. And actually, the Lieutenant Governor and Secretary of State really did know their stuff quite well. So I want to start with just how common are recalls in California. Since 2011, which is when I started compiling data of each recall, and actually Ballotpedia did it as well, so it worked out well. There's been 116 recalls in California and about 23 resignations. California removes people at a very high rate, over 75%. Michigan is actually the nation's leader in recalls. They have about 175 in that time. We'll actually get back to Michigan in a little bit because they changed their law. Oregon and California are basically tied for second. So these are just local, every type from coroner in some states to governor. This year, there's been 6 recalls: the Sonoma County DA, the governor, and 4 in one of the smallest towns in California, Vernon. Last year, there were 11. In 2019, there were 0. So it's not really going up. And just as a comparison, Idaho had 8 this year. Right now we're talking about a lot of changes in the recall. That always happens whenever there's a recall, a big recall. 1914, to see this happen, there was a big recall of a state senator. They immediately started discussing changes. They couldn't really come up with anything. In California in 2003, in Wisconsin in 2012. So not only that, diversity is really the rule in recall laws. Here's a quote from 1930s study by Bird and Ryan. It's actually a really good book, that in the cities of California alone, and I think they were talking about before 1911, there has developed such a variety of treatment of all the features of the law that it's difficult to think of any possible innovation left untried. Well, there were plenty, but it just shows how diverse recall laws can be. Now, as David mentioned, the big breakdown, the big difference between recalls are what's called the political recall or a malfeasance standard. It's a term I came up with because I don't like the technical term judicial recalls, which is quite confusing. You think that's a recall of a judge. Now, if you look down here, you'll see that there are most states that have a recall. In 19 or 20 states have recalls for governors. Virginia, probably not, that's the 20th, but let's keep them in there. And if you see, you'll notice that the political recall states have almost all the actual recalls that occurred. And if you ever think of a recall state, you'll think California, you'll think Wisconsin, you'll think Oregon, you'll think Michigan. You will not think these malfeasance standard states. There's only one recall of these 47 that occurred in a malfeasance standard state. That was Washington in 1981. That was during a window when Washington was more of a political recall state. The Supreme Court changed that law in 1984. So that wouldn't have gotten on the ballot. Interestingly enough, that official is still in office. So then the issue, actually, I guess I should go back for a second. The problem, the difference with the malfeasance and political recalls, well, a lot of people like it. Malfeasance recalls would effectively end the recall. It would severely limit it to very rare cases. They just don't get on the ballot that much. Additionally, to get on the ballot, it costs petitioners a significant outlay in time and money, and they'd have to beat back challenges both on the regulatory level and in the courts. So you could go for this, but understand that it would effectively end the recall as we know it. Now let's go to the signature requirements, because I think that's useful and got a lot of data here. But the big divide is between using turnout in the last election, a percentage of voters based on the turnout in the last election, and using based on how many registered voters there are. So as we could see, California has 12% of turnout in the last election, and that resulted in 1.5 million, a little less, 1.495 million signatures required. Now, Montana may seem to be a higher number, but it is actually quite a lot, a lower number, but it's actually quite a lot more. If California used Montana's law, it would have been another 700,000 signatures needed. Virginia, again, this is kind of a weird state. It has a recall trial. It's also not clear that the governor is impacted, but we'll see. California law for localities, and I think this is worth considering. California has a separate law that says, as you can see here, 10% or more, that if you have, if the city is over 100,000, so LA, San Francisco, you require 10% of registered voters. And in a lot of ways, this may be a superior standard, even though it feels a little less, it isn't less. Additionally, Newsom would have needed 2.2 million. Gray Davis got on the ballot, or Gray Davis recall started, because in 2002, California had the lowest voter turnout in its entire history. So that made the signature total much less. It had a 10% of registered voters, which is, doesn't allow for vagaries of turnout and a poor election result. It maybe wouldn't have happened, which good or bad, but it certainly would have allowed for a more consistent standard. So I kind of prefer that standard. Now, I guess let's go to the 4 types of recall laws, because this has been, very much on people's minds. And as we heard everyone talk about, there is the yes or no on the official and the same day replacement race. This is what California has. It's also what Colorado has. There's some advantages to it. Cost effectively, works out really well. It's only 1 vote. The big problem is the plurality issue that we've all talked about. And there's also the reality that the turnout drops between the first race and the second race. So the idea that the Democrats would have run somebody as a second candidate is not borne by history. In every single case, the opposition party would have won that election effectively, or did much, much better. And we see this not only in California, we see this in Colorado and Michigan, which had state level recalls like this, where there's a turnout drop on that second question, and sometimes extremely large turnout drop. The second standard is the yes or no and the different day replacement race, which has the disadvantage of vastly increasing the price of the recall. So you need 2 votes. In half of these 2 states, at least half, candidates are banned from replacing themselves. And some of them they can. And we've seen this in localities. In Fall River, Massachusetts, a mayor replaced himself in 2018. He lost the recall, 5-person race, won. So that's one idea that you put in. Maybe the governor could run against himself. That Fall River, Massachusetts mayor actually was just sentenced to a different type of term. So a little interesting. The third, which has been discussed and which I think the lieutenant governor correctly dislikes, is the yes or no and no replacement race, the position it filled as a matter of law. So in California, that's the lieutenant governor. In Oregon, that's the secretary of state. It's interesting, this is using a very democratic system, the recall, and replacing it with the least democratic system of not having an elected official, not having somebody elected to take that position. That's one negative. I think the bigger negative is it provides the veneer of legality. It really is like impeachment, and it has that same flaw that it pretends to be a non-political event. But as we've seen with impeachment repeatedly, it is not the case. And so you're kind of pulling one over on the voters. There are other problems for localities. It could result in them not having a quorum for voting, and they can't approve different budget matters. They can't approve anything. The bigger problem, possibly the biggest problem, is it will increase recalls. There's a thought that it will not, but that is not the case. We saw in Wisconsin, the lieutenant governor, whose position is less than that warm bucket of spit of the vice president in the US, had no reason to face a recall, but they still bothered and got 900,000 signatures. In North Dakota in 1921, they recalled 3 people. There's no question that they would just take the lieutenant governor and anyone else out who's in the line of succession. It's just kind of bizarre to think they wouldn't. Additionally, in the 2 most serious gubernatorial recall events that we've seen in the last year outside of California was Oregon and Alaska. Both of them had that. Have that provision and didn't stop people from collecting signatures and really trying a real effort. Oregon, the Secretary of State died and was replaced by somebody, and if they had that recall get on the ballot, it would have resulted in a constitutional crisis. So there's not too much of a benefit to it. The fourth model, and the one that Gray Davis has suggested, and the one that I think is probably the best model, is a new election. It really fits in with what people think of as an election. So we're just putting it in the same way. Okay, we got a new race. Scott Walker faced this. The real problem here is that due to the top 2 model, it's a double election. So we may want to use an instant runoff. We may want to do something else, but I think that's a particularly positive way of doing things. Here's a breakdown of it by state. so you could see. There's another provision that I think should be considered on the international level. There's something called what I call an absentee veto. As I'm sure nobody will remember, Romania's presidential recall in 2012 failed because of this. Turnout has to hit a certain amount, 40% failed. But I don't like this provision because it calls for voters to skip the election. On the other hand, Idaho has a great takeoff of this. They have what I call the Queen of the Hill provision, where the total vote has to top the vote of the last election for that candidate. So for Newsom, they would have needed 7,721,411 votes. It shifts the burden of turnout to the petitioners. And it feels like it would mitigate the complaints that a small minority of voters are choosing the candidate. So that's one provision that I'd say people should consider. I don't know that we're going to talk much about campaign finance, but I did want to point out Newsom raised about 72 million, which people thought was a lot. Scott Walker in 2012 raised 58.7 million, which is about 70 million in 2021 money, and in the state less than 1/6 the size, and in a time period when campaign money was not flowing. So it may not be that the campaign finance was such a big issue. So just to sum up a little, there's also positives to California's recall law. It actually has worked out very well on the local level. It removes unneeded roadblocks for locals, for people trying to do a recall. There's no ability for a city council to stop a recall, as happens all over the place. There's no requirement that you go to the court and spend a lot of money to stop it, as happens everywhere else or in many places. Michigan changed its law in 2012. It got freaked out after Scott Walker and after a recall in 2011. And what they've done is frustrated voters, making them go back for petitions repeatedly. It effectively is a sword and a shield, because elected officials who want to do a recall know how to get by these roadblocks, but regular voters will not. California's law doesn't do that.
Josh, if I can ask a follow-up question.
Sure.
It seems that, so there's an array of proposals that are being kicked around in California, changing the signature requirement, maybe making the LG automatically succeed, other proposals. To what degree do you feel like tinkering with the recall because I think we can agree that none of the proposals, even if you adopted a number of them, none of them would fundamentally change the recall. To what extent do you feel like these kind of tinkering around the edges changes are meritorious, given the very high failure rate of recalls to qualify or to succeed in California once they get on the ballot? So you and I have discussed that it's a very pyramidal data set where recalls tend to happen more and succeed more at the local level, and it decreases as you go higher in the state's hierarchy. So if the hypothesis is that we have a problem with the recall, it's too effective, it happens too much, or it's too overpowered for state officials, I think that that's not valid based on the data that we have. So to what extent do you feel like the recall actually needs change in California?
I don't know that it really does. I think that what we've seen is actually the recall boomerang. And the Republicans are a great example of this. So there's been 8 recalls of state level officials since 1994. 7 of them have been launched by Republicans. And what's happened is a disaster for the party. You look at the information to focus on is not the 7, it's the 1994. The party has gone completely into the toilet essentially since 1994. You look at the 20th century. Democrats controlled the governor's mansion for all of 22 years. In 1994, the congressional delegation was split 50-50. They had the assembly, however briefly. They were 2 years from having a Senate seat, which they had for all but 6 years of the 20th century. They were 6 years away from 9 of 10 presidential election victories. That was the story of the Republican ascendancy in the late 20th century, California. That was the cornerstone. They've launched recalls. Now, I don't think the recall is responsible for this, but it's certainly a symbol of it. They're looking for a shortcut, and it's just blown up in their face, and it never seems to work. It also didn't work for the Democrats in 2012 in Wisconsin. I don't see it working too well. The best example I could have of it working well is 1983 in Michigan. So, it's not too many. It's not a great tool for major partisan change. And I would say that, the fact that voters so approved it, and voters generally vote for this overwhelmingly. In California, 76%. In Minnesota, the last state to adopt it in 1996, it was 88%. So the fact that the voters like this idea, I think, should really mitigate any change. And from a policy point of view, from a politics point of view, I do wonder if the Democrats would really want to do this. It sort of goes against the grain of what the party's been talking about. They're talking about expanding voting rights. They're talking about protecting voting rights. To have this moment to pull back from voting rights in this one instance seems like it would clang. It just doesn't seem to fit with the rest of the party policy that's being pushed. And that's not to say they shouldn't be talking about it. I would be talking about it every moment of every day, saying, hey, they wasted $276 million until that election until 2022 is over. But to actually make that change, to push it, seems to be a questionable political decision.
Josh, thank you. I have run out of time for your segment, so I'm going to remove your pin. Thad, would you please turn your video back on? There you are. I'm now going to pin you. And Thad, take it away.
All right. Well, thank you so much, David, and thanks to all the organizers of this event and those in the audience who are sticking it out until late on a Friday night. I think this is clearly a timely and important event because this is what I see as a unique moment for recall reform in California. And what's not unique is some of the arguments, these important arguments that you've seen articulated very well by Secretary of State Weber and Lieutenant Governor Kounalakis about what's wrong with the recall, right? We've seen a focus on this plurality question, right? This question where we can, in plain language, right, that you can elect a new governor with less support than the old governor. We've seen a focus on, is the recall too easy? Should we have to have a broader coalition to go to the ballot that matches up with what Josh just showed us was true in most other states and true in some other levels of elections in California? I think there's a larger argument about having a recall that's more immune from political manipulation. Because one of the starkest things that we saw in this election here, right, as many people came to, I'm sure all of you on this Zoom are people who all your friends come to with questions about the recall. And one of those questions that I got asked over and over again is, why are there no good Democrats on this ballot, right? And the reason why there were no good Democrats is it was absolutely in the incentive of Governor Newsom to clear the field of all strong Democrats on the second question in order to protect him on the first question, and then to keep people out of the electorate. And so we see now 5 million people who participated in this election without casting a ballot on the second thing. That is exposed, right, a vulnerability. That's not healthy for democracy, and that's exposed a vulnerability. And then finally, the last principle, and I think it's great to have in this conversation a movement away from just mechanisms and reform ideas to the principles that they would achieve, right, is to think about how representative or not the recall electorates are, right? We've seen in this election held in an off-cycle year, in a month that we don't normally have as elections, we've seen turnout that is much lower, especially on that second replacement question than we traditionally see in California elections. And not only is it lower, but turnout has been narrower. And so we have a less representative electorate deciding this incredibly consequential question for our state. So these worries about an unrepresented electorate, about vulnerability to political manipulation, about two rules that don't make sense that are on that govern these two decisions on the ballot at the same time, right? These are all concerns about the recall process, which is a tremendously powerful thing that transformed the state from 2003 until 2010, right? That they have all been present and been talked about since 2003, right? Nothing that I've said so far is points that people were not making in 2003. And there, in fact, were conversations just like this in the wake of the 2003 recall. There were, legislature vowed to reform the process, and it all fizzled, right? And does that just mean that we're just talking about this again because this is the issue of the moment and it will fizzle again? I think not, for three reasons, right? I think there are three reasons that make this a unique moment for reform the recall in California. The first is that the group that would be in charge of starting any reform, right? It would have to start with the legislature. It'd have to start with the Democratic majority in the legislature, who would have to put something on the ballot with 2/3 vote in both the Senate and the Assembly. That group won the election rather than lost the election. Right, in 2003, if Democrats in the legislature, after just being crushed in the recall, after seeing 18 of their districts held by Democrats vote for recalling their governor, it would have looked like sour grapes, right? You can't push, you can't push for reform when you've just lost by the rules of the game. But if you've won by the rules of the game, then I think it gives you an ability to without looking like this is coming out of naked political ambition, to look at making some fair-minded changes to the process. Second is, in contrast to 2003, Democrats have a 2/3 majority, right? And in 2003, they didn't have the votes, right? They had the votes to pass things by majority, but nowhere near that 2/3 majority that would be needed to start reform. And so that creates temptation for Democrats to just sort of go alone on some ideas. And I was cheered to see that Secretary of State Weber was talking about bipartisan approaches rather than jamming something through with 2/3 vote, because at the end of the day, right, the third thing that has to happen for a recall for the recall process to change is for a simple majority of voters in California to say yes to those changes at a November general election, right? So if the legislature is going to craft proposals that will be successful in November of 2022, I think looking at what gains broad support is important. And I think where we are right now in this new UC San Diego Yankelovich survey that I'm going to drop a link to in the chat and then show some of the results of right now, it shows that there's actually a strong consensus across all demographic groups in California, and income groups and age groups and even partisan groups, that the recall process needs major changes. And there's strong support for some of those. Some have bipartisan support, many don't, but at least this provides a roadmap of some of the opportunities that may be present for reform. So let me just share my screen. And so this is a UCSD Yankelovich poll that was co-authored by myself and by Cassidy Reller, who's a PhD candidate here. And we're looking at California's perspectives on reforming the process. It was a poll done through the week of the recall with 2,812 Californians, diverse sample reflective of our population of registered voters in California. And importantly, we did 2 days of the survey on Monday and Tuesday up until 8 p.m. on Tuesday night. So people would view the recall sort of in the veil of ignorance, not knowing what was going to happen, not knowing what the outcome was. And then we restarted our sample again on Wednesday morning when the results were very clear. And here in short is what we found. The first thing was that by looking at the people who were in our survey overall, the people who said they participated in the last election, in the presidential election, the first recall yes/no question, and then the recall replacement race, we really see that the recall electorate, especially the replacement race, was not broadly reflective of California's population. So what these graphs show is, on the left-hand side, the overall registered voters, on the right-hand side, who was there in the replacement race. If you look at racial and ethnic diversity, California's registered voters in our poll were plurality Latino, but in the recall replacement race, plurality white. And Asian American voters and Black voters were underrepresented in that race. Also, so were low-income voters who were underrepresented, going down from 43% of the electorate to 39% of the, those making 50,000 or less. Those making six-figure incomes went up from 24 to 30% of the electorate. So one of the questions about reform ideas, one of the lenses through which we can evaluate them is, are they leading to a representative electorate, right? That was especially not there for that second question, which was tied to the first in a way that created a political incentive to have a smaller electorate on that second question. Second thing we see is that, unsurprisingly, due to human nature, right, views of the process clearly depended on the outcome. So on the left-hand side of this poll, we have how people answered this question last Monday or Tuesday before they knew the election results. On the right-hand side, we have the post-election results. What you saw was that the percent who were that was the smallest number. A lot of people were somewhat satisfied with the process. Going into the recall, 79% of Republicans somewhat or very satisfied with the process. That cratered after the recall. Democrats actually got happier with the process from before to after the recall. There's no big change for independents. Ironically, that is part of what has created this bipartisan openness to reform that I'll show you in a second. The openness to reform is higher in 2021 than it was in 2003. So the Public Policy Institute of California asked a question that we repeated in 2021 about, what do you think about the recall process? Does it need major changes, minor changes? Is it okay the way it is? Back after in Arnold's time, 58% of Californians said it needed major or minor changes. Now that is 68%. So there's more dissatisfaction with the process. And then we asked people, if you were voting in the next election, would you be open to a set of major changes reforming the recall process? Doesn't call out any specific ideas, but just says, are you open to major changes? What these graphs show is for every demographic and partisan group in California, we see a blue bar here that gives the percentage of people saying they're likely to support major changes, and then a green bar saying they're not likely to support those changes. The rest of the people said they didn't know. And what you see is for every one of those groups, the blue bar is bigger than the green bar. Right? That's true for every income group in California. It's true for every racial or ethnic group in California, with the strongest support coming from Black and Latino voters. It's true by at least 16 percentage points in every area of California. So even in things like areas of Northern California outside of the Bay Area or Central California, people were dissatisfied with this process. And it's true much more strongly for Democrats, very strongly still for independents, but by a narrow margin, there are more Republicans who say right now they're open to major changes to the recall process. The last thing that I want to close with are how some of the ideas, and what we're trying to do was poll on most of the major ideas that have been circulated, although I certainly love this discussion of bringing in diverse ideas from other states. Josh's calling of the Queen of the Hill idea from Idaho. There was a version of that I've been envisioning with the same goal, which is that make the recall have to get 50% of registered voters or some percentage of registered voters in order for it to succeed. Many states do that with propositions. This puts the onus of generating turnout on the petitioners' signatures, on the signature gatherers, because you rather than having this problem of finding a small electorate and trying to win in an election that very few people turn out in. So let's look at some of those ideas, right? Some get strong support, right? Making California a malfeasant state in some way, right? Having a recall having recalls have to be justified with concerns about corruption or criminal acts, right? That is something that gets 66% support, only 26% opposition. The rest were don't knows, and that is something that's strong, that has strong support within Democrats, Republicans, and independents. The idea that you heard from Secretary of State Weber of increasing the signature gathering threshold to more in line with what you see in other states and legislative district rates, that also has strong support, 54 to 35. Voters are up for the idea of trying to fix this plurality rule. So they supported that general concept, and then a couple of the specific fixes they strongly support. So one is holding a top two runoff in the replacement race that wins by about 20 points. and then holding a second election, as many of those states as you saw do, if and only if the recall succeeds. That has 49 to 37% support. So I appreciate the argument that it is more expensive because it calls a second election. But the one response to that argument would be, well, it only gets more expensive if the recall is successful, right? You don't pay that cost. If the recall is not successful, you wouldn't have paid that cost here. And it takes away that incentive for the sitting governor to muscle everyone out of the recall replacement race, right? If a governor lost, then the new field could take the strongest candidates from each party. There's a statutory change that's, at least last I looked, was pending the governor's signature, and potentially there may be challenges to it, but it would prohibit payments for signature gatherers. That's something that voters strongly support. There were some ideas that didn't have a ton of support. Lieutenant Governor Kounalakis might be happy to hear that it was a very close race, but with 43% saying yes, 41% saying no about replacing the governor with the lieutenant governor. Ideas that did not have support were letting the governor run in the replacement race and delaying the recall until the next even year election. All right. So the overall message that I think that this UCSD Yankelovich Center poll shows is that this is a time where voters, even more than in 2003, want to see changes. A broad cross section of voters want to see changes, and there are a number of reforms that are indeed quite popular. Thanks very much.
Thad, if you don't mind, let me ask you a question before I switch over to Jessica. And in maybe a minute, can you tell me what your view is on this idea that, I guess, as Joshua put it, the idea of switching California to being a malfeasance state, it's somewhat deceptive. So it's interesting to me that was the highest polling reform. I'm wondering, do you agree with Josh's assessment that seemingly unbeknownst to the people, or maybe they knew, but I suspect they didn't, that the thing they're in favor of would arguably destroy the recall in California by making it unavailable? Right. So do you think that was something that was part of that the respondents were aware of, or more generally, do you agree with that point?
Right. So I think there are 2 points here. One is that this is a useful caveat that we put in the poll report up front, which is these are quick descriptions of complex reforms meant to serve larger principal purposes. We didn't want to put pro-con arguments in them. This conversation that the state is now having, it needs to be larger to get at these questions, right? But I think this question of whether a malfeasance standard would essentially end the recall, which we also found 74% support for keeping some version of the recall in the process. I think if that were true, people would not support it. But I think there are ways to write in, that there are ways to say that the supporters would have to make a clear argument. If you enshrine in the Constitution, right now we have a Constitution that's silent on the grounds for the recall, right?
It's quite clear that no sufficiency of reason is required.
Exactly, right. It's screamingly silent because the people who wrote that, had the very clear example of the U.S. Constitution, that they did not follow, right? If a standard, even if it only needed to be rhetorically met, was written into the Constitution.
So not instituting a bar of proof, but just a statement requirement.
Right. Not a judicial standard, right? Yeah. But one that would have to be interpreted in the court of public opinion in a recall campaign.
Yeah, I think when, consistent with your results, past polling in general, in other contexts, shows, very high, like 70 plus support for the general concept of maintaining the existing degree of political power that California's direct democracy tools currently have. The voters almost never favor reducing their powers. So in future polling, I think, this is an important nuance to bring out that some of these proposed reforms, even though they sound good, stated in 10 words or less, they could actually wind up reducing the people's direct democracy powers. And I think once you tell people that, I think that'll change their minds about whether they want some of these reforms. Professor, thank you so much. That was Professor Thad Kousser. I'm now going to unpin him. Go ahead and turn off your video. And we are now going to switch to Professor Jessica Levinson. Adding a pin, and I am turning myself off. Professor Levinson, take it away.
All right. Well, it is, I think I get everybody at 5:43 on Friday. So I am going to try and be quick and clear and relatively high energy. And so obviously we've just had a great conference. And what I want to do is maybe try and sum up a lot of what we've heard and kind of remind us of why we're here at all. And I did actually, so you don't have to look only at me, I put together a few slides and who I am, how to reach me, etc. Let me see if I can. All right. Why do we have the recall at all? I know we've talked about this, but who can resist this picture of Governor Hiram Johnson from 1911 with his fists up fighting for direct democracy? Presumably, I actually have no idea what the context of this particular picture is, but he is there in a fighting stance, and he is in part the reason that we have direct democracy. I think I saw Joe Matthews on the participant list, and he has written a lot about this, and he could certainly correct me real time on some of what I'm about to say. But the high level, of course, is that in 1911, Californians said, yes, we need to be able to bypass our lawmakers. In our infinite wisdom, we should be able to make laws and amend the Constitution on our own. We should be able to pull back on laws, the referendum, and we should be able to tell elected officials who are particularly transgressive of whatever norms we have that, no, we want to recall you. And David, I really enjoyed the conversation you just had with Thad about like, well, we don't have a standard for when you recall. And I think the answer is that's exactly right, in part because we looked at the standard for impeachment on the federal level and essentially said, like, what the blank does that mean? Other high crimes and misdemeanors, I'll get to what I think about the definitional issues in a moment. But the idea, of course, is that there were special interests that dominated the legislature, and we needed to empower the people. And I think that many people would agree at this point that, in fact, it is those very special interests who are now dominating the process. That these processes of the initiative, the referendum, and the recall, which I think we can't totally talk about in isolation, are in fact now used in many ways, perhaps predominantly by the very interests that we were most worried about. Now let's focus on the recall for a second, and I'll just kind of retread something that we've already talked about, which is, or actually, I think I'll frame everything I'm about to say in this way. I'm going to say two things that can never be squared. One, I think the recall process is really riddled with problems. And two, I'm not sure we should try and solve those problems. And so we can talk about the problems in the recall, but let's remember something that we've all talked about the last 2 hours or so, which is that we don't have successful recall campaigns very often. We don't see these recalls reach the ballot on the local level, on the state level, very often at all. And when they do reach the ballot in those rare instances, then they're often not successful. So I'm not sure that, given we've had the recall for 110 years and we've had 2 gubernatorial recall elections, one was successful, one was not. This keys me to our next slide here. I'm not sure that this is where, frankly, we should spend our time, even though I think it's absolutely inarguable that, yes, there are plenty of problems and weirdness with our recall process. Now, let's focus on one of the things I think is the biggest problem, which again, we've already touched on today, which is, let's imagine a hypothetical situation where there are 100 people who show up to vote in the recall election. 51 say, we want to recall Governor Newsom. So he's recalled. He will no longer be the governor. And then 7 vote for Larry Elder, but nobody else got more than 6 votes, which means that Larry Elder, who is only the choice of 7 people who showed up out of 100 that day, is now the next governor. This is something that Secretary of State Weber has talked about. It feels just inherently anti-democratic. And so one of the things that I want to point out is that this process, which is supposed to empower us, which is supposed to, in fact, be the ideal of a democratic process really can undermine democratic choices. Now, obviously that didn't happen. Obviously, Governor Newsom resoundingly defeated the recall, but under our system, that is possible. So now, why did we end up with this particular recall? I'm not going to spend a lot of time talking about the specifics of Governor Newsom's handling of the pandemic, et cetera. I do want to point out one thing, though, which I think indicates that we had this election because we really did have a perfect storm of problems. So obviously, this was a recall that was already started. The effort was started before the pandemic. And there was a state court case that I think hasn't been discussed enough, where the signature gatherers, the proponents of the recall, said to a judge, we need more time. We need more time to gather signatures, in part because of the pandemic. It's hard for us to reach people. And the court said, okay, and Governor Newsom did not appeal that decision. Nobody appealed that decision. And if it weren't for that decision, I do not think we would have had this recall election. And it would have looked even, frankly, less important to reform the recall. And then, of course, I mean, the two most overused words in California politics now, of course, there was French Laundry, which fed into a lot of preconceived notions about the governor. Of course, there was this handling of the pandemic that could never make everyone happy. But I think really that state court decision that allowed for signature gatherers to have more time was incredibly consequential. And shout out to the reporters who followed that at the time and really got that right away. So we did have the recall. We are here. We are talking about efforts to implement reform. And I'm going to be fairly brief about efforts to implement reform. The main thing that I want to say, and David, this is something that you said at the end of your conversation with Thad, and I wanted to highlight it, which is, while I think you certainly could reform the process, even though I don't think there's a pressing need to do so, anything that looks to the voters like you're taking away their power, I think will immediately become very unpopular. If there's one thing that it really unites California voters, it's their desire to not give up their power. So I think it'll be very important if any of these proposals do reach the ballot. I think it'll be very important to see how they are phrased for the voters. But if we think about any proposal where people kind of complain about, why are we voting on this? Judicial elections, city controller, district attorney. I mean, there are a lot of offices where arguably we don't really need to be voting on them. It might be better off to have an appointment. Anytime we're faced with the idea of, do you want to stop voting for who your state court judges is? No, we have to have that power, we say. We have to be able to hold people accountable. And I think really any of the big reforms when it comes to the recall could potentially fall into that trap. So because I think I'm seeing that I'm running out of my time a little bit quicker than I anticipated, I'll highlight that there are basically kind of two buckets of smaller reforms. And I think they both come from State Senator Josh Newman. Why? Because he himself, of course, was the subject of a recall. He then was able to come back to the state legislature, but he has two bills for people who are interested in more details, SB 660, SB 663. And they would, in my mind, a little bit of tinkering around the edges. 660 says that organizers of recalls can't pay signature gatherers per signature. So you'd have to use a different method of payment, like per hour. And the other bill, 663, really focuses on this idea that if you're the subject of a recall, you can have more time and more information to try and look at the people who sign and say, are you sure you knew what you were signing? Were you misled? I want to verify that you are a valid signature. Would these revolutionize the recall? I don't think so. The bigger reforms would take constitutional changes. And as we all know in California, if you require constitutional change, what does that mean? It means you have to go to a vote of the people. And again, back to what David and Thad were talking about and what I just mentioned, you have to be really careful that you don't make it sound to the voters like you are trying to take away their power. So, one of the things, obviously, increase the threshold for the number of signatures required to qualify a recall effort. I think we already talked about this, that California has the lowest requirement in terms of percentage of signatures that you need to gather to get a recall on the ballot. Again, we should remember these recalls typically don't qualify, but could that be a good idea? Yes. Would it make recalls more expensive? Of course. Something I mentioned before, changing the standard or creating a standard. Right now, David, as you said, it specifically says like for any reason. What about changing the standard? I'm not a big fan of these like technical new definitional things where frankly, anybody who wanted to recall Governor Newsom thinks he fit within that standard. And anybody who didn't thinks he did not fit within, whatever standard we're going to apply here. If you look at what's happening on the federal level, there's so many definitional problems with what kind of, quote unquote, bad conduct should fall within this bucket. Which words do we want to use to try and embrace this bad conduct? And how much help does it really give us? I don't think that much. I think this is really about, I want this person to keep their job or I don't. And if you don't want the person to keep their job, you're going to find that, whatever you think they did falls within that new definition. And then something else that we talked about, particularly in the first hour, this idea of eliminating the second question and just saying the lieutenant governor could be the next governor if the governor is in fact recalled. I think this one actually, I'm not the lieutenant governor, and obviously she wasn't a fan of this. I think this makes a lot of sense and it would take a lot of the kind of partisanship out of this because in California, we know that you would very likely end up then with another Democratic governor. And, I think for a host of reasons, it also makes sense in terms of it. You get somebody who the people voted on, and you don't have that system of 7 people, for instance, voting for Larry Elder. Now, this brings us to, I'll try and sum it up. This brings us to, is any of this going to happen? I think for the reasons that we talked about. One, the recall needs to be reformed, but it kind of doesn't need to be reformed because we don't use it that much. Are we really going to do the big reforms? Probably not. We'll probably see some tinkering around the edges, maybe that can be done legislatively. Why won't we do those big constitutional reforms? I think because the people just won't go for it because it will feel like they're taking some of their power away and that they can't hold elected officials accountable. And so who do we have to blame for this in the end? Not to throw stones, but I think it's those very happy people in the photo we can perhaps blame. And I think that was maybe a depressing note to end on, which is typically my usual. David, I'll stop sharing screen. And I think I came in at 12 and a half of my 10 to 15 minutes.
Very well done on the timing. Two follow-up points because we have about 3 minutes left. One thing that I would suggest on the idea that the lieutenant governor automatically replacing the governor is a safe choice because you'll get a Democrat. Whenever I'm considering reforms to direct democracy, I always try to look to the future and think about unintended consequences. California has changed red to blue back and forth a few times, and it's pretty solidly blue now. So yeah, that does work. But in the future, if it switches, and you have that automatic replacement, you could wind up replacing a governor that you favor with someone from a party that you don't. So I would be worried about unintended consequences there. What do you think about that?
So I think that's absolutely possible. And obviously this is a very different, we didn't get into this too much, but it's a very different California than it was in 2003, for instance. Right. At least that would be somebody who is elected with a greater percentage of the vote than the people for question number 2. That would be my quick response to that.
Yeah. The other point you made that I thought was interesting, among many, but I only have time for one more, which is you point out that one of the risks here of pursuing constitutional change, which is obviously necessary to change, some of the more fundamental aspects of the recall. One of the risks there is either, like there's always a problem of going to the ballot with constitutional change, and it's a relatively high bar. And you run the risk of the voters feeling like, you're trying to take away some of my powers. I'm not doing that. So, those and other things potentially, impel this process into statutory changes that the legislature could make. And given that political reality, that's why one of the things I'm focused on is something the legislature can do, which is changing by statute, resolving the mystery of the replacement candidate procedure, which Secretary Weber and I talked about. The statutes are vague, and so it basically leaves it to the Secretary of State to choose between party primary versus independent. One of them's a lot easier and one of them's a lot harder. That's something the legislature could change by statute. And to me, it leaves alone the larger structure of the recall, but it fixes one of the big standout stupidities of our recall process, which is the clown car. You get, 45, 135, however many people running to replace the potentially recalled governor. I think that's low-hanging fruit, and it's an easy fix. What do you think?
I love eliminating the clown car. I will come out in favor any day of eliminating the clown car, even if it means I will not hear from my friends what the blank is happening. Should I just vote for Angeline? It's worth it for me.
Yeah, I particularly loved her campaign statement that her platform would include mandatory bubble bath days. I think that's fantastic. I love that. But yeah, I would not be sad if I got fewer phone calls from national media saying what the blank is going on in California. If we fix this one thing, that would be great. Professor Levinson, I'm glad we got to agree on a positive and note of agreement. You were fantastic. I'm going to now remove your pin, and I'm going to thank everyone who participated today. I want to particularly thank the Citron Center, the Institute for Governmental Studies, my center, the California Constitution Center, Lieutenant Governor Kounalakis, Secretary Weber, our panelists, Josh Spivak, my colleague, my good friend, my brother in arms, Professor Kousser and Professor Levinson. Thank you so much. Thank you everyone who hung in. There's 50 people still on this at 6 o'clock on a Friday. You are true nerds and lovers of public policy. I salute you. Thank you, everyone. I think we've had a very productive discussion here. Enjoy your weekend. That's all we have.